This meeting is called to order. Mr. Trubman, has anyone signed up for public comment?
Morning, Commissioners. We have no requests for public comment this morning.
Good morning, Ms. Gonzalez.
Good morning.
I understand we have some cases to reconsider on agenda item 3.
That is correct. There are 2 cases before you today. Commission Appeals is requesting a letter of continuing jurisdiction in case number 2496629. This case was voted on docket 26 on June 30th, 2020. On July 2nd, 2020, an incomplete and unauthorized draft decision was accidentally mailed. The appeal deadline expired on July 16th, 2020, and there is no evidence of an appeal being filed. However, because the decision is voidable, Commission Appeals is requesting a letter of continuing jurisdiction to allow an authorized decision to be processed. Commissioner Alvarez?
I agree.
Commissioner Dimerson?
I agree.
And Chairman Daniel?
I agree.
Thank you. Commission Appeals is also requesting to resubmit case number 2505009 on a future docket. This case was voted on docket 29 on July 21st, 2020. The Commission voted to deem the appeal timely and resubmit the case on the merits. However, the summary incorrectly stated that merits testimony had been taken. Because there is no merits testimony to resubmit, Commission Appeals request to resubmit the case for appropriate procedural consideration. Commissioner Alvarez?
I agree.
Commissioner Dimerson?
I agree.
Chairman Daniel?
Agreed.
Thank you.
Thank you. We'll now consider tax liability cases under agenda item 4. I believe we have 3 tax cases on docket 32.
That is correct. Starting with TD 190820719. Commissioner Dimerson?
I agree with staff recommendation.
Commissioner Alvarez?
I agree with staff's recommendation.
Chairman Daniel?
Agree with staff recommendation.
The next case is TD 200220320. Commissioner Dimerson?
I agree with staff recommendation.
Commissioner Alvarez?
I agree with staff's recommendation.
Chairman Daniel?
Agree with staff recommendation.
The last case is TD 200230320. Commissioner Dimerson?
I agree with staff recommendation.
Commissioner Alvarez?
I agree with staff's recommendation.
Chairman Daniel?
Agree with staff recommendation.
Thank you.
We have no fair housing cases under agenda item 5. Is that correct?
That is correct. There are no fair housing cases.
All right, let's move to agenda item 6. We have no wage claim cases pulled for additional discussion on docket 32.
That is correct. There are no wage claim cases pulled for discussion on docket 32. However, there are cases remaining to be voted.
I'll move we accept staff recommendations on the remaining wage claim cases on docket 32.
I second the motion except for those cases in which I am dissenting as reflected on the wage claim short form dissent list for docket 32.
And I concur with the chairman's motion except for the cases on which I'm dissenting as reflected in the UI short form for docket 32.
The motion passes with the exceptions noted. Let's move to agenda item 7, consideration of unemployment insurance cases on docket 32. Please proceed with that.
Case number 2460446. Commissioner Alvarez?
The AT decision should be affirmed. I do not dispute the AT ruling that the claimant should be disqualified due to a receipt of wages in lieu of notice. On the separation, the claimant was discharged after she called in absent due to her personal illness. While the employer alleged that the claimant was fired due to her tardiness for several days leading up to her discharge, they have not provided no direct evidence of her tardiness. Per the claimant's credible testimony, she was late on the isolated incidents, and she had never been warned about tardiness. The evidence was insufficient to establish that the claimant was discharged for misconduct connected with the work. Affirm the AT, no misconduct, chargeback, wages in lieu of notice, disqualification from 10/13/19 to 10/26/19.
The AT decision should be modified as the employer did not intend to appeal the wages in lieu of notice determination. That issue should be affirmed. As to the job separation, the parties agreed that the claimant was notified in late September about the importance of punctuality in the office. Shortly thereafter, the claimant continued to be tardy on multiple consecutive days, as evidenced by the still framed from the employer's security video in evidence. The employer made its expectations clear to all employees, but the claimant chose to ignore them and was repeatedly tardy. Based on this evidence, the claimant was not working to the best of her ability, and her continued tardiness constituted mismanagement of her position of employment. Accordingly, we should modify the AT decision: misconduct, no chargeback, adequate employer response. The claimant received disqualifying wages in lieu of notice from October 13, 2019 through October 26, 2019.
Modify the AT, misconduct, no chargeback, adequate employer response, wages in lieu of notice disqualification, October 13, 2019 through October 26, 2019.
Short form dissent.
I have a short form dissent for Commissioner Alvarez.
Case number 2467856. Commissioner Dimerson.
This case should be reheard. In file documents that are already part of the record, the employer stated that in order to perform his job, the claimant was given access to the internet. However, per an unofficial copy of the claimant's conditions of community supervision, the claimant was not to have access to the internet through any method or manner unless it was equipped with approved tracking software beginning August 26, 2019, for any reason, unless specifically ordered by the court. In its appeal to the commission, the employer submits a document that appears to be a copy of a signature page of the claimant's conditions of community supervision. While the copy has a watermark bearing the word unofficial, it is nevertheless signed by a magistrate. The case should be reheard to enter the document into the record and to confront the claimant as to whether the document is accurate. If so, the claimant's failure to apprise the employer of his internet restrictions would constitute the withholding of pertinent and material information, since internet access had been given to the claimant in order to perform his job. Such a withholding would not have been responsible or an exercise of good judgment and would have been a violation of the employer's code of ethics policy and misconduct connected with the work. Accordingly, we should rehear the case for the signature page evidence in the employer's appeal to the commission and confront the claimant as to whether the documentation related to his condition of community supervision is accurate.
The decision should be affirmed. There is no evidence that the claimant was ever asked about or ever misinformed the employer regarding his probation. The claimant testified he had been approved to work for the employer, and the court was aware that he was doing what he was doing. The employer has only submitted an unofficial document to evidence parole conditions. The employer has failed to establish the claimant was discharged for misconduct connected with the work. Affirm the AT, no misconduct chargeback.
Here.
Case number 2485971. Commissioner Alvarez.
The decision should be reversed. The claimant was discharged for refusing to pay employees for weekend work in a manner that could violate the Texas Pay Act and the Fair Labor Standards Act. The evidence established that the additional work could take between 5 minutes to 2 hours, and the employer wished to pay a daily rate of $15. At that rate, even an employee making minimum wage would be unable to work more than 1.38 hours without the employer violating the law. The claimant received guidance from the agency personnel on the correct method of payment and had followed the employer's instructions before learning it could result in liability. Since the claimant was discharged for refusing to comply with the instructions that could violate the law, the claimant was not fired for misconduct connected with the work. Reverse the AT, no misconduct chargeback.
All right, this is a difficult case. At the outset, I'd like to make it clear that in all of the interactions that my staff have with callers, they're very careful to explain, give legal advice, act in an attorney capacity outside of TWC, or give official instructions from the Texas Workforce Commission on what to do to comply with laws. In order to even reach my office, callers must listen to a disclaimer that the attorneys cannot give legal advice. They give basic information and answers to questions and recommend that callers consult whatever agency enforces the laws in question, and obtain legal advice from a private sector attorney. That having been said, I'm satisfied that the claimant was given correct information about what the FLSA requires regarding how overtime pay must be calculated when an employee is paid at 2 or more different rates within the same work week, not only from my office, but also from the U.S. Department of Labor. Staff does our best to not become involved in disputes within companies as to how to comply with the law. Extremely unfortunate that such a controversy led to a work separation, but under the unusual circumstances of this case, I believe I must recuse myself from the decision in this case.
My vote is to affirm the AT, misconduct, no chargeback.
Since there is not a majority vote, the original decision will stand because Commissioner Dimerson recused himself. Commissioner Alvarez, did you want to dissent?
Yes, please.
Okay.
Case number 2500192. Commissioner Dimerson,
The appeal tribunal decision should be affirmed. The claimant spent 2 weeks at her new post before she resigned due to dissatisfaction with workplace conditions. Claimant because she alleges that the manager for the morning shift would call her every day to complain about the claimant's work, even though the claimant thought she was doing her work properly. It is understandable that the claimant would be annoyed by the manager's comments, but the claimant testified she was never written up for her job performance. As such, it can be concluded that the claimant's job was never in jeopardy. Moreover, the claimant's testimony about her bringing her concerns to the employer's attention appears to be contradicted by her fact-finding statement. She stated she never spoke with the supervisor about the issues she was having and did not speak to anyone about the alleged favoritism and stress the job was causing her. In sum, the claimant did not establish that her working conditions were intolerable, and her quitting was therefore work-connected good cause. We should therefore affirm the AT decision, voluntary leaving, no chargeback.
The decision should be reversed. The claimant quit her job due to the consistent complaints she received regarding the quality of her work. The claimant had made several requests for the proper cleaning materials to do her job, but the materials were not provided to her. Since the claimant was subject to regular complaints from her employer without being provided the tools to perform her job, she had good cause connected with the work to quit. Reverse the AT, no voluntary leaving, chargeback.
Reverse the AT, no voluntary leaving, chargeback.
Short form dissent.
I have a short form dissent for Commissioner Dimerson.
All right, thank you.
case number 2500826. Commissioner Dimerson,
The appeal tribunal decision should be reversed. The claimant testified that he was terminated because the employer had run out of work. However, this is not consistent with the claimant's fact-finding statement, which was taken closer to the time of the job separation, where the claimant stated that he was terminated for work ethic and attitude. Indeed, the employer testified that the claimant had received verbal warnings about his job performance and was given a written warning for not clocking out for lunch and incomplete work at the job site. Nonetheless, the final incident consisted of the claimant not working while clocked in, showing up late, and leaving early before completing his job. As such, not only should the employer's testimony be given greater weight, but the claimant's actions or lack thereof should also be viewed as work-connected misconduct. Moreover, any delay between the final incident and discharge should not result in penalty to the employer, since the delay was not unreasonably long and the ultimate reason for separation was the claimant's poor job performance. We should therefore reverse the AT decision, misconduct, no chargeback, adequate employer response.
The decision should be affirmed. The employer discharged the claimant for alleged poor performance. The employer asserted the final incident occurred in early February of 2020, but the claimant was not discharged until February 24th, 2020. It seems unlikely that the employer would have delayed discharged the claimant as long as they did his performance was poor as performance was as poor as they alleged. The employer has failed to provide sufficient evidence to establish misconduct connected with the work. Affirm the AT, no misconduct chargeback.
From the AT, no misconduct chargeback.
Short form dissent.
I have a short form dissent for Commissioner Dimerson.
Thank you.
Case number 2509910. Commissioner Alvarez.
The decision should be reversed. The claimant ceased working after she had a stroke on February 25th, 2020, and was informed by her doctor she could not return to work until March 16th of 2020. The claimant submitted her resignation on March 3rd, 2020 because she was unable to work. Since the claimant's resignation was a result of a medical issue, she should not be disqualified from benefits. Reverse the AT, no voluntary leaving, bill reimbursing employer.
The AT decision should be affirmed. The claimant testified that she resigned because she was afraid of being discharged for attendance. However, the employer credibly testified that the claimant's job was not in jeopardy, and the claimant could have requested a medical leave of absence instead of resigning. The claimant also testified that a doctor did not quit. The claimant did not establish good work-connected cause for quitting, and we should affirm the AT decision. Voluntary leaving, reimbursing employer not billed.
Affirm the AT, voluntary leaving, reimbursing employer not billed.
Short form dissent.
I have a short form dissent for Commissioner Alvarez.
Case number 2513330. Commissioner Dimerson.
The appeal tribunal decision should be reversed. The claimant was discharged because he drove the vehicle he was operating off the side of the road, resulting in it having to be towed away. As the only party to appear for the hearing, the employer testified that the claimant had a previous accident and had been trained and retrained on safe driving techniques. The employer went on to testify that the claimant had received verbal warnings. As such, the claimant knew or should have known that the employer was placing high emphasis on safe driving. Nonetheless, as it related to the final incident, the employer testified that there was no visible reason as to why the claimant would have driven the truck off the road. In addition, the employer stated that when the claimant was confronted about the incident, he was unresponsive and said he did not know why it happened. Since the claimant did not appear at the hearing to testify as to what occurred, and since one of the employer's witnesses stated that by looking at the pictures of the incident, the accident probably occurred because the claimant was not paying attention, was distracted, or just didn't follow the curve in the road, the preponderance of the evidence establishes that the claimant failed to properly pay attention to his surroundings, resulting in the vehicle he was operating being towed away, which constituted misconduct connected with the work. We should therefore reverse the AT decision, misconduct.
The decision should be affirmed. The employer alleged at the AT that the claimant had an at-fault accident. The employer's testimony was vague. The employer testified that there were photos of the scene but failed to produce those photos. The employer alleged that the claimant had prior warnings but failed to produce those warnings. The employer's testimony was also inconsistent with its response to the notice of initial claim. The employer said nothing about the February 23rd incident being fault at the accident. Instead, the employer said the issue was that the claimant was late and incurred out of mileage expense. The employer's evidence is insufficient to establish misconduct connected with the work. Affirm the AT, no misconduct.
Affirm the AT, no misconduct.
Short form dissent.
I have a short form dissent for Dimerson. Commissioner Dimerson, sorry.
Thank you.
Case number 2519219. Commissioner Alvarez.
The decision is not supportable. The claimant has submitted additional correspondence showing he was given the option of being laid off or remaining employed by being in debt to the employer for vacation time for the days he was paid. Additionally, It is unclear if the claimant would have been required to continue working while vacation time was being used or owed. This case should be reheard to admit the document into evidence and take personal evidence regarding the employer's vacation policy.
The AT decision should be modified. I do not dispute the valid claim ruling and agree that the chargeback determination should be voided. As to the job separation, I would agree that the claimant was laid off as a result of the COVID-19 pandemic since he worked as a cook and no further work was available. This case is distinguishable from those where employees were offered emergency pay or regular pay through PPP loans during a period of no work. Therefore, I would agree to modify the AT decision, a valid claim, no misconduct due to disaster, void chargeback.
I would agree to that, Commissioner Demerson, if that's okay.
Agreed.
All right, so have a unanimous vote.
Case number 2524279. Commissioner Alvarez?
The decision is not supportable. The claimant was completing shadow hours at a gym prior to filing his initial claim. The claimant was not paid, and the shadow hours were called an internship. The training was so that the claimant could be hired to work at the gym, and it was not associated with an educational program. These shadow hours do not appear to be a legitimate internship. Therefore, the claimant was entitled to be paid under FLSA, and the gym would be her last employer. The case should be reheard to determine if the correct last work was named.
The appeal tribunal decision should be affirmed. I agree that the claimant filed a valid claim. As to the job separation, the claimant quit so that she could pursue another job. The claimant stated that there was still work for her had she not quit. There is also no evidence to indicate that the claimant's working conditions were intolerable. As such, the claimant quit for a personal reason and without work-connected good cause. We should therefore affirm the AT decision. The claimant filed a valid claim, voluntary leaving, no chargeback.
Affirm the AT valid claim, voluntary leaving, no chargeback.
Short form dissent.
I have a short form dissent for Commissioner Alvarez.
Case number 2531598. Commissioner Demerson?
We should affirm the appeal tribunal decision. The claimant was discharged for taking items from the store without paying for them. Despite the claimant's statements that his actions were unintentional, testimony from 2 employer witnesses who viewed the video of the final incident established that the claimant was aware of the merchandise in his shopping bag prior to adding his own items to the bag. Because the claimant exited the store without paying for the items and without bringing the situation to the attention of staff, the claimant mismanaged his position of employment. We should affirm the AT decision, misconduct, no chargeback. In the alternative, if my fellow commissioners have doubts, we could grant a rehearing for submission and review of the video of the final incident.
The decision should be reversed. The claimant was in the employer's store as a customer. In the self-checkout line, the customer before the claimant left some items in one of the bags. The claimant was ill and did not notice the items and placed his purchases in the same bag and left. When the employer confronted the claimant, he returned the items. The employer's witness testified that there was no policy that the claimant violated. The employer further alleges that he has video providing the claimant saw the items in the bag, but the employer refuses to present the video as evidence. Because the employer refuses to present the evidence used as a basis for the discharge, the evidence is insufficient to establish misconduct connected with the work. Reverse the AT, no misconduct, chargeback.
Affirm the AT, misconduct, no chargeback.
Short form dissent.
I have a short form dissent for Commissioner Alvarez.
Case number 2540448. Commissioner Alvarez?
The decision should be reversed. Due to the claimant's pregnancy, her doctor requested work accommodations so that she would not be working with COVID-19 patients. The claimant ceased working for the employer on March 30th of 2020 when she took a leave of absence because no accommodations could be made. As the claimants properly notified the employer of the situation and no accommodations were made, the claimant had good cause connected with the work to cease working. Reverse the AT, no voluntary leaving, bill reimbursing employer.
We should modify the appeal tribunal decision. The claimant took an unpaid leave of absence because she believed that her request for an accommodation based on her pregnancy could not be met. However, the employer was not aware of the need for an accommodation, so it is unclear whether the claimant properly made the request. The claimant took her leave immediately upon submitting a doctor's note and without allowing the employer an opportunity to grant her accommodation. Under these circumstances, the claimant initiated the job separation without good cause connected with the work. Accordingly, we should modify the AT decision, voluntary leaving, reimbursing employer not billed, and impose adequate employer response.
Reverse the 18, no voluntary leaving, bill reimbursing employer.
A short form dissent.
I have a short form dissent for Commissioner Dimerson.
Thank you.
Case number 2540661. Commissioner Dimerson.
We should modify the appeal tribunal decision. Prior to the date of the initial claim, the claimant stopped working for the employer while work was still available due to an on-the-job injury. As such, it was proper to find that the claimant initiated the job separation. However, because the job separation resulted from the claimant's injury and was based on medical advice, the claimant should be qualified for benefits and the employer's account should be protected from charge under medical separation analysis. Thus, we should modify the AT decision, no voluntary leaving, no chargeback, MVI.
I would agree with Commissioner Demerson.
Agreed.
Have a unanimous decision.
Case number 2544491. Commissioner Alvarez.
The decision should be reversed. Section 201.091E of the Act only provides that an individual is not eligible to receive benefits for benefit periods in which the individual works the individual's customary full-time hours. The AT improperly used customary hours for someone in the claimant's profession and not the claimant's own customary full-time hours. The claimants customarily worked 50 to 60 hours per week. During the week of May 10, 2020 through May 16, 2020, the claimant only worked 33 hours. The claimant did not work her customary full-time hours and should not be disqualified. Reverse the AT, customary full-time hours eligible.
The appeal tribunal decision is supportable because the claimant stated that she worked the maximum hours available for the week in question, and she had been working the modified schedule for several weeks. The claimant is considered to have worked her customary full-time hours for that period. We should affirm the AT decision. The claimant worked her customary full-time hours from May 10th, 2020 through May 16th, 2020.
Reverse the AT, customary full-time hours eligible.
Short form.
I have a short form dissent for Commissioner Dimerson.
Thank you.
Case number 2547669. Commissioner Alvarez.
The decision should be reversed. The claimant worked as a substitute teacher. She was scheduled for 2 days of work, but she could not work due to illness. Shortly thereafter, the school took spring break and no further jobs were available because the school closed due to the pandemic. The claimant's absences due to the illness was not misconduct. Reverse the AT, valid claim, no misconduct, bill reimbursing employer, void adequate response.
The AT decision should be modified. I do not dispute that the claimant filed a valid claim. As to the job separation, per employer policy, failure to accept work for 3 consecutive days constitutes job abandonment. Thus, this case should be rendered under section 207.045 of the Act, since the evidence shows that the claimant resigned when she rejected or failed to accept available assignments available on March 3rd, 4th, and 5th of 2020. Documentary evidence in the record establishes that the assignments were available to the claimant on those days. Although the claimant missed work on March 3rd due to illness, there is no evidence that she failed to accept assignments thereafter due to medical reasons. As such, I would not agree to an MVI in this case. The claimant abandoned her job without work-connected good cause, and we should modify the AT decision. Valid claim, voluntary leaving, reimbursing employer, not bill, separate adequate response.
Modify the AT, valid claim, no misconduct, bill reimbursing employer, void adequate response.
Oh, thank you. I have Commissioner Dimerson, you found under section 207.045 of the Act, and Chairman Daniel, you found under section 207.044 of the Act. So I have a voluntary leaving and a misconduct.
I have no misconduct.
Okay. Oh, you have no misconduct? I'm sorry.
Yes.
Could you repeat your vote, Chairman Daniel?
Modify AT, valid claim, no misconduct, bill reimbursing employer, void adequate response.
Okay. My apologies. All right.
Ms. Gonzalez, let me consult with my team real quick. All
Okay.
right? All right, thank you, Ms. Gonzalez. We're going to go, I agree with the chairman.
Okay. So I have a valid claim, no misconduct, reimbursing employer billed, void adequate response. Is that correct?
No, we had reimbursing employer not billed.
Okay. Okay.
Ms. Gonzalez, I could agree with Chairman Daniel's vote.
Okay. All right.
All right, and go ahead and reread the vote for me, and then I'll register, weigh in.
Okay. I have for Chairman Daniel, a valid claim, no misconduct, reimbursing employer billed, void adequate response.
Okay. All right, and I guess Commissioner Alvarez agree with that. I'll short form dissent.
Okay. Thank you.
Thank you.
Case number 2550146. Commissioner Dimerson?
We should affirm the appeal tribunal decision. Am I still on? All right, let me have your camera. I think we zapped out.
You're on.
I am on. Okay. Yeah, totally went blank here. So we should appeal tribunal decision. The claimant was discharged after the employer learned that the claimant had not been completely forthcoming when responding to questions on his job application. Specifically, the claimant failed to disclose that the job separation from his last job occurred because he had surrendered his teaching license due to having engaged in an inappropriate relationship with the student. Considering the employer's mission and the claimant's job position, such information was very relevant and clearly related to the job. Thus, by failing to disclose this information, the claimant mismanaged his position of employment, and we should affirm the AT decision. Misconduct, reimbursing employer not billed, adequate employer response.
The decision should be reversed. The claimant was discharged because the employer believed that he misrepresented the reason he left his prior employment. The claimant testified that he left teaching because of excessive focus on testing. The employer alleges that the claimant left teaching because of an improper relationship with a minor. The employer did not provide any evidence that the claimant was going to be subject to a non-renewal due to these allegations, nor did the employer present any evidence that the claimant's license was in jeopardy at the time he surrendered his license. The claimant testified that he voluntarily gave up his license, and police investigated the allegations and no charges were ever filed. The employer's evidence is insufficient to establish misconduct connected with the work. Reverse the AT, no misconduct, bill reimbursing employer, set aside adequate response rationale.
Modify the AT, misconduct, reimbursing employer not billed, adequate employer response.
short form dissent.
I have a short form dissent for Commissioner Alvarez.
Case number 2555360. Commissioner Dimerson,
We should affirm the appeal tribunal decision regarding timeliness. The claimant filed a late appeal simply because she failed to read the determination, not due to any technical or system issue that the Texas Workforce Commission may have experienced. Thus, since the claimant's appeal is not timely, we do not have jurisdiction to consider the underlying merits. We must therefore affirm the AT decision. The claimant filed a late appeal, voluntary leaving, no chargeback. Even if we deem the claimant's appeal timely, the employer should not be charged for benefits. Based on the claimant's testimony, she first stopped working when she was absent for a week with the flu. Then, when she was ready to return to work, there was no further work available due to the pandemic. Under either scenario, the claimant would be qualified for benefits and the employer's account should be protected from charge. Accordingly, we could modify the AT decision, deem the claimant's appeal timely, no misconduct, no chargeback, natural disaster.
Let me see. Ms. Gonzalez, could I ask Commissioner Demerson to state again his ruling on this?
Okay, so we could therefore, two situations here. Therefore, affirm the AT decision. The claimant filed a late appeal, voluntary leaving, no chargeback. But even if we deem the claimant's appeal timely, the employer should not be charged. And so we could also modify the AT decision, deem the claimant's appeal timely, no misconduct, no chargeback, natural disaster.
Ms. Gonzalez, I would agree to that.
Thank you.
Reverse the AT, timely claimant appeal, no misconduct, no chargeback, disaster.
This concludes consideration of UI cases pulled for additional discussion on docket 32. There are remaining cases to be voted.
Move we accept staff recommendations on the remaining UI cases on docket 32.
I second the motion except for those cases on which I am dissenting, as reflected on the UI short form dissent list for docket 32.
And I concur with the chairman's motion, except for the cases on which I'm dissenting, as reflected in the UI short form dissent list for docket 32.
Motion passes with the exceptions noted. This brings us to the end of agenda items 3 through 7. Let's pause for a few moments to reset for the rest of the meeting. Thank you.
How you doing, Chairman?
I'm doing all right. How are you doing?
I'm doing good.
Good. All right. Agenda item 8's up next on the list, but we're going to postpone this item to a future meeting. Brings us to agenda item 9. This is discussion, consideration, possible action regarding the submission of Texas Workforce Commission non-discrimination plan of the non-discrimination and equal opportunity provisions of the Workforce Innovation and Opportunity Act to the U.S. Department of Labor Civil Rights Center.
Okay. Good morning, Mr. Chairman, Commissioners, Mr. Cerna. For the record, I'm Boone Fields, Deputy Director of the Regulatory Integrity Division and also the State Equal Opportunity Officer. I've briefed your offices, and if it pleases the Commission today, I'm presenting for your approval the WIOA Section 188 Non-Discrimination Plan for the Assurance of Non-Discrimination and Equal Opportunity in the WIOA One-Stop Delivery Program. Upon your approval, this non-discrimination plan will be signed by Mr. Cerna, TTWC's Executive Director, also the Governor's designee, pursuant to 29 CFR 38.4 and 38.55. And after that, we will deliver it to the U.S. Department of Labor Civil Rights Center. Thank you.
Comments or questions?
No, Chairman.
None here.
Do we have a motion?
Yes, sir. Hey, Boone, it's nice to hear from you again.
Thank you,
I move
sir.
that we approve the non-discrimination plan for submission to the Department of Labor.
Second.
And then second, we're unanimous. Thank you.
Thank you.
Item 10, discussion, consideration, possible action regarding statewide initiatives funded with Workforce Innovation and Opportunity Act, temporary assistance for needy families, adult education and literacy, child care, or other state level funds. Let's see, I have up first adult education and literacy math assistance call center RFA.
Correct. Good morning, Chairman, Commissioners, Mr. Cerna. For the record, Courtney Arbor, Workforce Division. The Math Assistance Call Center solicitation procurement was conducted to help eligible adult ed students in preparing for the math portion of the Texas Certificate of High School Equivalency exam. Assistance will also be available to AEL students who lack sufficient skills in math to participate effectively in society. Last week, staff brought forward a request to execute an award for the AEL Math Assistance Call Center, and commissioners asked staff for additional briefing. Those briefings were completed this last week, and today staff requests approval to award the grant for the AEL Math Assistance Call Center. I'm happy to answer any questions you may have.
Comments or questions?
Chairman, I have a few comments, if I may. Commissioners, moving forward on these AEL grants, and first of all, I wanted to thank Courtney and Jen Trope for putting this together and meeting with the staff multiple times regarding this specific grant. I asked that the commissioners moving forward on these AEL grants, if we could ask that solicitations contain a requirement that eligible applicants be Texas-based entities since they are delivering services to Texas students, if allowable by law. In this case, the grantee will assist Texas AEL students with preparation for Texas certificates of high school equivalency exams. So that was just a comment that I wanted to make regarding this specific agenda item.
Thank you. Additional comments or questions?
None here.
Do we have any motions?
Yes, sir. I move that we approve the recommended applicant and issue one grant awarding totaling $477,000 for the AEL Math Assistance Call Center RFA 32020-00214.
Second.
Been moved, seconded, we're unanimous.
Thank you, commissioners, and I'll be happy to bring the procurement and contract staff to your offices this week to brief on what the law allows for any Texas preferences in procurement.
Thank you.
Thank you.
Courtney.
And have discussion on any other flexibilities.
Thank you.
Thank you.
Okay, that's it for agenda item 10. Let's move to agenda item 11. Just consideration of possible action regarding guidance on resource utilization and implementation of services and strategies to target disaster relief efforts and public health emergencies, including those funded with the Department of Labor's Dislocated Worker Grant. The first one I have is Enhanced COVID-19 Skills Development Fund grant funding across FY 2020 and FY 2021.
Good morning, Chair Daniels, Commissioners, and Mr. Cerna. This is Christina Ramos for the record, Christina Ramos, Workforce Development Division. Today, under agenda item 11, we have two items for your consideration. I will present the first one for your consideration, and then Reagan Miller will present the second one. At the April 14th, 2020 meeting, commissioners approved a series of funding recommendations, including up to $10 million in Skills Development Fund to support training in high demand occupations in direct response to needs identified by COVID-19. To date, 50 grants have been awarded, totaling $9,947,500 across a variety of sectors. These grants are projected to train over 5,300 workers, with 1,006 workers currently in training and 743 workers that have already completed training since these grants began in early May. We are continuing to receive new applications, pushing the amount of funding needed in excess of the $10 million that has already been approved. Staff seek commission approval for up to $5 million for use across FY 2020 and FY 2021 skills development funds for COVID-19 skills grants.
That's a
Are there
question.
No questions or comments, Chairman.
Yeah, Mr. Chairman, I'd just like to say that the Texas Restaurant Association and the Dallas Community College, I know they're utilizing this program through their Texas Restaurant Promise Certification Program, and they've been pretty excited about it. And so I hope that we'll continue to get activities through this program, and good job, team, with it.
Well, you know, it had been my hope as we made these training dollars available earlier this summer that we would see this kind of use. So very, very happy to see that community colleges and others are able to utilize these funds to get the kind of training that I think will be beneficial for folks as they're progressing in the workforce or re-entering the workforce. So do appreciate that. Any additional comments or questions? Do we have any motions on this?
Yes, Chairman. I move that we approve up to $5 billion for fiscal year 2020 and fiscal year 2021 in skills development funding for COVID-19 skills grants.
Was that million?
Second that motion.
You said million, right?
Yes, sir. I said move that we approve up to $5 million for
Okay,
fiscal year
Thank you.
2020 and 2021.
Thank you. Commissioner Demerson, I heard you seconded it.
I did second that.
We're unanimous. Thank you.
Thank you.
And I believe next on the agenda is childcare under this COVID item. So Chairman, Commissioners, for the record, I'm Reagan Miller with the Child Care and Early Learning Division. This morning for your consideration are adjustments to the board contract year 20 child care local match targets for 4 workforce boards. As a result of COVID, some boards have identified challenges in securing local match. Boards derive much of their local match from entities that were also impacted by COVID, such as colleges and schools. And when these entities closed, the services that were provided and were previously used as match were no longer available. We surveyed all of the boards to determine how much match they would not be able to certify in board contract year 20. And based on this, we have recommendations for the 4 boards listed in the discussion paper, totaling $891,710. Several other boards are still working with their educational institutions to determine if they will be open and providing match qualifying services this fall if those educational institutions remain closed or provide a reduced level of services that would qualify as child care match. We may have some future recommendations for your consideration. Also, we have worked with finance to confirm that we can make these local match adjustments while still allowing the boards to access their full amount of federal matching funds. And I'd be happy to answer any questions.
Comments or question?
No, Chairman.
None here. Thank you.
Do we have any motions?
Chairman, I move that we reduce the board match target for Panhandle by $23,268, North Central by $381,982, Dallas by $385,261, and Texoma by $101,199 for the board contract year 2020.
Second.
Been moved and seconded. We're unanimous. Thank you.
Thank you.
I don't believe we have anything additional under this item. Is that correct?
Yes, sir, that's correct. We have nothing additional.
All right, do we have a legislative report today?
Yes, sir. Good morning, Chairman Daniel, Commissioner Alvarez, Commissioner Dimerson, and Mr. Cerna. For the record, Tom McCarty, External Relation. On Saturday, President Trump signed an executive order to authorize an additional weekly payment of $400 per week for individuals receiving at least $100 in unemployment insurance benefits, with the state covering 25% of that cost. We're currently waiting further guidance from the U.S. Department of Labor on how this program is to be implemented. As a reminder, Reagan Miller will be presenting in a virtual town hall being hosted by House Committee on International Relations and Economic Development Chairman Rafael Anchia tomorrow morning at 9 a.m. on the topic of child care as economic development. Chairman Anchia has requested that TW speak on several points, including the importance of child care in relation to economic development, how the COVID-19 pandemic has affected child care operations and exposed vulnerabilities, and what the state can do to ensure high quality childcare is available for parents throughout the state. The town hall will be broadcasted on YouTube and Facebook Live. The virtual town hall will be open to all members of the Texas legislature. While there are not formal committee meetings, with the COVID-19 pandemic preventing House committees from holding formal in-person meetings, House committee chairs are making use of these virtual town halls to hear reports from the public and experts on topics of importance to their committee and the legislature. This concludes my remarks, and I'm happy to answer any questions you may have.
Comments or questions?
None here, Chairman.
None here.
Thank you.
Thank you.
Mr. Cerna, do we have an executive director's report today?
No, sir, I have nothing to report this week.
All right. Thank you very much. We have one item of business that needs to come back before the commission. I've been asked to clarify votes on agenda item 6. This is wage claim cases. I had a motion to accept staff recommendations on the remaining wage claim cases on docket 32. Could you please confirm your vote on this issue? Commissioner Alvarez.
Chairman, I second the motion except for those cases on which I'm dissenting as reflected on the wage claim short form dissent list for docket 32.
Thank you, Commissioner Alvarez. Commissioner Demerson.
And I'm going to concur with the chairman's motion, except for the cases on which I am dissenting as reflected in the wage claim short form dissent list for docket 32.
Thank you very much, gentlemen. Appreciate that. We just needed to clarify that for the record. Is there any other business that needs to come before the commission today?
None here, Chairman.
None here.
Thank you. Do we have a motion to adjourn?
Chairman, I move that we adjourn.
I also second that motion with Commissioner Alvarez's nice tie and shirt there, the combination. But I second that motion to adjourn.
Well, with the two of you, the pressure's on to be a sharp dresser on this. I feel the pressure over here.
Alvarez.
I hang it up here every week. It's
Well,
anyone wants to
we do have a motion and a second to